Hello all, welcome to one of our Juris North monthly discussion. Today we have the pleasure of having John Camacho from the United States and my guilty pleasure to have our chair at Westminster, Dr. Anna Chronopoulou. Anna, your floor. So this is my presentation, so this is all yours now.
Thank you so much for coming. I would like to introduce Dr. John Camacho to you. He's got a Juris Doctorate at South Texas College of Law, and he's also got a master's degree, master's in arts, in philosophy at University of Missouri, St. Louis, the United States, and he will be talking today about the problem of luck in acquiring tort justice. Thank you. John.
Hi, everyone. Thank you all for
coming. Share your screen.
Yes. So, good morning, everyone. Or to me, it's good morning over here in the States. So I will say that this project, definitely started off on my a little bit as I was working for a law firm in personal injury on motor vehicle cases, and particularly my job is to write demands. And so quickly, what I'll do is I'll quickly evaluate the case for the attorneys. And one of the things that I noticed is you could tell almost very quickly, depending on who had insurance, whether or not they would actually whether they could actually acquire justice. And so here's my outline. First, I must let out the problem. It has both practical and philosophical features. So both. Then I'll give a brief detail on insurance policies. I'll stick to normally private insurance, which is common in the UK and in the United States. This is a bit of a contrast to, I would say, the Australian system, tort system, where their policies are don't necessarily go through private insurance. And so what's happening sort of globally is this contrast between one UK American system and an Australian system. And so in the background is in the background of this problem is those concerns. And here I offer two dilemmas, one against corrective justice and the other against civil recourse theory. Both theories are theories on the foundations of tort law, trying to justify and explain and even make cohere at times all of the systems of tort law, trying to put it all together. And are we justified in having it? There's different formulations of this problem. They call it the normative problem. They call it justificatory problem, the explanatory problem. It's generally a sense of, is this system the right system? Are we correct in having? Are we justified in having it? I think that it offers some very practical dilemmas that these theories fail due to certain dilemmas of luck. And I'll try to offer a different approach through what's called virtue jurisprudence, which is a view of the law through virtues and particularly excellences. And so generally my final proposal will be to argue that tort law is more concerned about excellences in terms of practical excellences, like being an excellent driver, as opposed to being moral excellences, or like something that or more wrongs, such as something that corrective justice might hold. So let's just get started. Let's go. First, again, this problem has the problem of luck and acquiring tort justice. One has very practical sense. So there's a very I think a little bit famous 2020 $301 billion Texas dram shop case, which is a case where we have two plaintiffs, Tamara Kindred and Tammy Anderson. They were driving home, and a drunk driver hit them, who was over drinking and was being overserved. beer. Literally, it's called Beer Belly Sports Bar. Can't make that up. And the jury awarded $301 billion. Now, again, this this business, Beer Belly Sports Bar, actually did not have a liquor, an insurance policy for liquor, which is technically not required in Texas. So because it's not required for businesses to pay, it's nearly everywhere else they have to pay for it. But because it's not required, it means that Beer Belly had to pay out of its own pocket. Of course, they couldn't handle that judgment, $301 billion, and so they went. So the business went bankrupt. Um, Again, the plaintiffs weren't going to receive a dime of this, right? So um, even though the judge ruled this, right, even though tort law seemed to work, there's not a problem with, negligence or the law necessarily particular tort laws. There was a wider problem in terms of the problem of the insurance law. So the problem here was that the insurance law, Texas didn't have a law to require a liquor license and to pay for those damages. And so because of that, the plaintiffs wanted to send a message to everyone, to all businesses, and they thought, and the attorneys thought, this is the best way to do it. We're going to, we're going to shock people. We're going to do something to sort of shock people, and in terms of such a high amount, a jury award, and hopefully that did scare people, frankly, in terms of that. But again, it's not necessarily. But again, you think about like the point of tort law. You think of the point of, is this like justice? Is this supposed to be justice when they're not going to receive a dime, when the grandmother and the granddaughter are dead, and you're trying to send a message? So it also shows that tort law has many different purposes, not just to, like a law and economics person would say, just to compensate injuries of victims, but it can also send a social message. It can have a broader importance. And so if that case hasn't shocked you, or at least showed the importance of this, there's also philosophical dimensions, right? So first, as I sort of was talking a little bit earlier, before the talk a little bit with Anna and Jorge, the problem a lot of the times is not necessarily, as this case shows, is not justifying or being correct in negligence, right? It's not really, the problem here isn't that we have to look at negligence and fixed negligence, or maybe, instead of duty, breach, causation, damages, it should be something else. No, that's not that's not really what happened here. What really happened here is that one individual tort itself cannot do all this work when it's in a system that is also not lacking. And so just like so particularly in motor vehicle cases, tort, whatever the tort is, negligence, battery, whatever, it works within a system. And in these cases, it works in conjunction with insurance laws, traffic laws, health laws, medical, obviously health, the medical laws. It works in conjunction with those. So for example, in order to get, now I'll go a little bit further, but in the next slide, but, to get that money, you have to, you need all this other, just to prove that you're injured, you need evidence laws, you need all these other sort of other laws to also work in conjunction with that. And sometimes the problem is that interaction, not necessarily the law itself. So here we can formulate the problem sort of pretty quickly. Victims' ability to acquire compensation in motor vehicle cases depends on, one, being lucky that the tortfeasor has sufficient insurance to pay the victim, or the victim, or what you're going to see was that the victim has to pay for her own insurance to pay the damages in the event of a default. So in the event of a default tortfeasor. So when beer bellies can't, pay, literally they have to sort of pay on their own, right? The victim is can have again, I'm going to go a little bit later, but they can have their own sort of policy to protect themselves against sort of bad tortfeasors. And so, insurance policies, again, you guys probably already noticed if you own a motor vehicle, but there's really two different kinds. One is liability. So, on the first horn is whether or not liability policy just works like this. You pay a premium, let's say, 50 bucks, $100, and any actions you do that, any negligent conduct that you do that causes damages, um, there's a policy limit. So in this case, so in most sort of cases where it's a motor vehicle, usually like in Georgia where I live, it's $25,000. So if you get in a car wreck and you're responsible, then then the other person has up to $25,000 to cover those. That you're covered up to $25,000. The insurance company is supposed to pay that out. Not every insurance company will fight tooth and nail to pay that $25,000, but they will. But that's what's available. And if it goes over that, then you're responsible. Then you're held on the hook. So a lot of the times, of course, if you mess up, you want the insurance company to pay that money as fast as possible so that you're not on the hook for it. And again, let's say, and sort of going a little bit back, what if there's a default tortfeasor like in beer bellies where there's you get in a car wreck and the person who hits you drives away, they don't have insurance, and you're injured. Well, the law allows you to protect yourself. You pay money on your own, you pay a premium, and in the event of a default tortfeasor, someone who doesn't have any money or doesn't have an insurance policy, they may have money on their own, but they may not, but they don't have an insurance policy. And if they don't, then you can either go after them individually, which frankly no attorney will really take the case. You'll have to mostly go to small claims court on your own, and that's one option. And usually the amount of money is not going to cover your medical bills. And even if you do get a judgment, there's no guarantee that the actual person will pay it, because most likely the person can't even afford insurance. They probably don't have enough assets to even really go after. So really, realistically, that is a possible option, but it's not a realistic option for most people in car wrecks. What a realistic option is that you pay for uninsured or underinsured motor coverage. So when someone hits you, and they don't have insurance, your own policy you're paying into will protect you. And so that's sort of a background of these policies. Again, it's a little bit different because of these policy limits allow for a certain limit. They go from 25 to 50 to 100. If you get hit by, like, let's say a ride sharing service like an Uber or a Lyft, those policies are $1 million. So literally the difference between you getting hit by an uninsured person and an Uber, you have up to either you can get $0, no money there, or up to $1 million. Now, are you going to get $1 million? Of course not. Unless there's amputation or your injuries have to sort of justify the compensation there. But generally, that's based on them policies and your injuries. That's how much money you can try to get, or at least that's what can be owed to you. That's probably a better way of saying it. So, given this, so I haven't talked much about corrective justice, but corrective justice is a view in tort law that's had different incarnations, from Ernest Weinreb, Jules Coleman, even John Gardner, and their views is that when the injured person, when someone's let's say in a car wreck, when the person acts negligently and harms someone else, that defendant owes a duty to repair for the victim's injuries. So the main sort of crux of corrective justice is this duty to repair, because this is what's obligating the defendant to pay those damages. So when we ask why why does this person have to do this? Just because they got hit, can't can't someone else pay? Can't the state pay? For this person's injuries. Car wrecks happen all the time. Why am I obligated to pay? Well, you're obligated to pay because you did something wrong, and so it's a wrong based view, and in order to correct that, you owe a duty to repair the victim. Okay. So, and again, we want the different, variations of corrective justice. Um, uh, um, but I do think that's the main sort of crux of it. Also, again, it starts with the most fundamental relationship is between plaintiff and defendant. So when corrective justice is one of the reasons why it became popular was its ability to criticize law and economics, which has been a dominant view in law schools, especially because law and economics, just compensation can't um, capture the bilateral structure of the plaintiff and defendant. That is very fundamental to that is the fundamental relationship between every tort case. You have a defendant and you have a plaintiff, and this relationship can be explained through the defendant's duty to repair. And so, my here I'll look at the slide and we can say, okay, well, John, we talked about luck. You talked about, luck. You talked about these insurance policies. What, how does this affect corrective justice? Well, first, corrective justice requires that victims are lucky and that tortfeasors have insurance to satisfy their duty of repair. So even if victims and tortfeasors have no insurance, when victims are unlucky and they don't have any, then sorry, let's move this a little bit. If victims are unlucky and tortfeasors have no insurance, then tortfeasors cannot fulfill their duty of repair to their victims. So even if victims are lucky that tortfeasors have insurance, the tortfeasor avoids the duty of repair because they cited away to the insurance company. So first, let me go back to this first paragraph here, because it is a little bit much to unpack. Corrective justice, in order for someone to satisfy their duty of repair, in order for someone to pay, right, they need to have insurance, right? They need to have their own insurance in order to satisfy them fully. Now, it's possible that someone's independently rich or well off, and they can just automatically, someone doesn't need insurance and they can pay out of pocket for their medical coverage. Now, if medical costs, again, this is why tort law depends on a little bit where you are. So, for example, I know in South America, I have a colleague there in South America, and medical, visits will cost $300-400 for, an injection, while here in the United States it's about $3,000-4,000. An MRI scan here is about $2,000. ER visits can range from, depending on how many X-rays and CT scans, it can range from $3,000 to $15,000. All of that money, again, it's going to be different. Will shape how a defendant is able to satisfy their duty of repair. If my bill's $400, okay, maybe I can pay that to my victim and I can satisfy their duty of repair. But if it's $40,000, which is very common, if you get an ER, a physical therapist, if you get orthopedic, if you get an injection, if you get an MRI, let me tell you, in my work right now, that bill will at least be $30,000, and that's conservative, frankly. So corrective justice will a little bit be shaped a little bit on that note. But even if victims are lucky that tortfeasors have insurance, tortfeasors still avoid their duty of repair because they can sign it away to the insurance company, who will solely determine what is a fair amount of compensation to repair the victims. This is a very important point because it really depends on agency law and principal law, because here the tortfeasor is supposed to be the principal and the insurance company is supposed to be their agent. However, the principal usually is the person who's supposed to dictate how much money is to pay. However, most cases, the insurance company is going to take that money decision-making responsibility. If you call up your insurance company and say, hey, look, I want you to pay this person, all the money, I want you to pay them this amount. The insurance company is not going to necessarily, they're going to take it into consideration, but they're also going to say, don't worry, you're fine. They're going to, sweep you on the rug and say, look, you signed away your right to make a decision on this, and you don't really have a decision in terms of how much compensation that you're supposed to repair. So while tortfeasors someone may say, well, tortfeasors don't really have a voice in the amount of compensatory repair to their victims. And therefore, if you don't have a voice in how much to repair, then you can't say you are actually satisfying your duty to repair. Does that make sense? Hopefully that's clear. On the second horn, a victim's ability to acquire compensation. So again, the first horn is on liability, right? It's on the liability policy. The second horn is on the UIM policy, the UIM policy. So it's going to be the same way for civil recourse when I criticize when this objection goes against them. So you can see the structure of the dilemma is the same. On the second horn, victims' ability to acquire compensation. Sorry, hold on. Just let me go previous. Sorry. The second ability to acquire compensation. Sorry, apologies. I'm going to minimize this again. Is that okay? All right. Visibility to acquire compensation MVA in motor vehicle case depends on victims paying money from their own policy to protect themselves against uninsured, insufficiently insured tortfeasors. So UM means no policy, meaning like they just didn't pay for an insurance policy. UIM means that they just don't have enough. So your medical damages are so high that it exceeds the amount of coverage available. So what you sort of see here is, and this why is this a problem for corrective justice, is that it actually indicates that there's another relationship between you and yourself and your future self to protect yourself against future tortfeasors. So while corrective justice will focus on the bilateral structure of plaintiff and defendant, and these two are like the main structures, fundamental structures. Tort law is also grander, right? There's much more here at stake, including you protecting yourself from future harm, and you're able to compensate yourself through UIM policies. So the idea is that you're paying for your own protection, in the future, so that if someone does hit you that doesn't have it, then that doesn't have enough, then you're good. You're protected. And corrective justice really has an answer for liability, but I don't think it has an answer for UIM policies. So it doesn't really have an answer for what I call protective justice, or a different version. So now I'll go into civil recourse theory. Civil recourse theory starts with Benjamin Zabursky. Gosh, last name's always the weird, and John Goldberg. This view has been a little bit more popular in legal realms because it is focuses on the descriptive account is not a view on wrongs, it's more about an opportunity. So similarly, how corrective justice had a principle of to duty repair, civil recourse says that there's a principle of an opportunity for recourse. So the principle of opportunity for recourse states that when there is a car wreck, the only thing that you're allowed as a victim is the opportunity to get compensation or to get recourse, not that you'll actually get it. So it's really just the opportunity itself that's allowed, and not that you're focusing on, and not actually getting it. So it's sort of again, a lot of people sort of, think it's a little bit, a little empty in terms of, you know, inputs, in terms of sort of a powerful view. It's not the most powerful view you'll ever hear, but at the same time, it's an intention that way to be descriptive and to account for how you're only allowed an opportunity to go to court. So when you get injured, you get a right. You get a right to get recourse, and that's all you get. It doesn't mean that you're guaranteed anything, and which, it's not wrong, but, and again, this also still has its own problem. Also has its own problems, and so on the first horn, abilities of a victim's ability to acquire compensation depends on being lucky, because that a tortfeasor has insurance, and corrective civil recourse fails to account for the different financial opportunities for recourse there are. So as I said, in the dram shop case, you can they have no policy, so the opportunity for $0 is a lot different than the opportunity for $1 million, right? So if you get hit by an Uber driver, where their policies are standard 1 million. Um, and again, this is a little bit of a hit to a little philosophy, but they, there's a view in metaphysics called ostrich nominalism, and the greatest thing about it is that when they ask you to explain something, they put their head on the ground like an ostrich and say, "I don't want to ask these questions. I don't want to ask these questions." And so I will say, so civil recourse can argue that, look, I will say nothing. I do not need to actually have a response to this, because they're right. Yes, you could have yes, you have an opportunity for $0 and you have an opportunity for $1 million. It's just luck, right? And so they may sort of accept it and say, look, that's a part of the system, and no problem. However, um, they their view needs to provide, I think, a more robust account, or even a more significant account, frankly, of opportunities, of what they mean by an opportunity, what it means to have an opportunity, and to use that right. So the right to $0 and the right to $1 million, those are very different rights. And here it's a little bit like, as I said, a theory of cars that without any petrol, without any gasoline. It's just, it's not saying how the system works. We want a system, like, we at least want to be justified in a system that we think is going to work, and not just, oh well, it's lucky or it's not. And so I don't think I don't think it's so recourse, and at least for the liability horn, it doesn't really show why the tort system can be successful, or if it is in fact successful. Um, and they may not say it doesn't have to, because they may just sort of bite that bullet, which is on them. And again, so on the second horn, again, the UIM horn, a victim's ability to acquire compensation depends on, again, victims paying for their own policy to protect themselves. And civil recourse fails to say anything on why a victim can be her own source of recourse through her policy. So their argument is the civil recourse argues that the state provides this right to you, provides you this opportunity for recourse to go and get it. Well, you know what? I can also be my own source of recourse, because I'm paying and I'm making it on my own. And they need a story of why the state allows victims to protect themselves, um, and um, and how that works. So, and here, I don't think, again, every dilemma and every objection is created equal, right? I don't think everyone, all of what I said is all, all these views are going to be destroyed or something tomorrow. That's not going to happen. But I do think that there are strengths and weaknesses on all of them. So, by my own work, I do think for the corrective justice, the first liability view, um, I think that really turns on agency and conflict of interest laws, in terms of agency and principles, in terms of whether or not a victim can actually um, sign her, or defendant really sign away their responsibilities to an insurance company. That happens every day, but I think that's where this view will turn on. I think the second one actually is a little bit stronger because it attacks the bilateral structure of the plaintiff and defendant relationship, because it provides another account where there's you and your future and yourself, protecting yourself, and that aspect of protective justice is something that is not focus on it all. And so it also leads to other things that are also important, and like protecting yourself. Like, how come there's more to tort law than just the wrongs? There's also ways to protect, again, uh, know the fight against tortfeasors in a different way, not just through correcting the world, but also protecting yourself. And for civil recourse, the first one I think is a bit strong. Theory of tort law must explain why and how the system works. That's any adequate theory of tort law must explain why, how the system at least works, and why why it's important, and where it goes wrong and where it doesn't. Um, I don't think civil recourse really says that. Again, it tries to be too descriptive, I think, here, and not actually talk about the purpose of tort law. So, and on the second horn, I think this is not as strong, but still pretty good. Civil recourse must explain why the state allows victims to protect themselves and against bad tortfeasors. And so, particularly, what is the public policy behind this reasoning? We allow this in the law, but again, there's many different public policy reasons for why. For example, an insurance contract may be torn apart by a judge and say, well, you know what? As a matter of public policy, we're going to go here, and you insurance company are going to have to pay for this. And there are many different cases like that. What I've tried to do here, and again, the arguments are there, are in sort of the main half of the paper, and I guess the last sort of third of the paper is this idea of virtue jurisprudence. It is the view that has not gotten a lot of traction, frankly, but I think it actually is helpful here, mainly because it talks about excellences in terms of and it provides more tools to actually explain tort laws. So why is it important to send a message? We've seen that tort law also, tort law is important because it also sends a social message. It provides compensation. It allows you to protect yourself. Tort law isn't just about one thing. To me, I mean, clearly there's multiple things that's going on here, and it's growing. Uh, the way it's being used is not just compensation. It's not just it's not singular in that respect. And so because of that, we can maybe hopefully we can look to this view to explain it. And so mainly, obviously, it strives to the virtues is not just in terms of moral virtues or like courage or like courage or vices like greed or something, or it's about these tools of social prudent social practices. Like prudence is a virtue, and tort law really clearly strives to improve today's social activities. Like the purpose of it is not just to compensate, but it's also to help make our lives better in terms of for example, the amount of laws that have grown in terms of premises liability in response to people just walking on the street, and the amount of notices, failure to warn, and failure to, whether or not something's open and obvious. There's certain things within the law that are in the law that are pushing us to be better at driving, pushing us to be better. We're better, our cars are much more sophisticated and than they were 50, 60 years ago. It's encouraging us to be more excellent drivers. And that's really what the purpose, like if you look at each system, each sort of different cases of premises cases, or if you look at, just motor vehicle cases, negligence cases, motor vehicle wrecks, um, we're pushing to get better at what we're doing. And that can really be explained through virtues. as opposed to compensation and civil recourse. I think it encourages also, if you look at just the virtue of prudence, obviously that's very connected to negligence. A reasonably prudent person, that's an objective standard, right? That's very clear, and negligence cases that you want someone, not someone who's necessarily moral, right? Like, we're not saying that you have to be the most morally great person. And I try to give a case of where there's the moral driver and the prudent driver. And the prudent driver is usually it's actually usually better. The prudent driver may not make that mistake, but the moral driver may make that mistake and really apologize, but they're just bad drivers. And so, and to me, that's really the difference, is that we're looking for something that's more practical in terms of our prudent, and being more prudent, and as opposed to just being grounded in some sort of moral concept like reciprocity or autonomy or something like that, where those are all still really good foundations. But I'd rather have someone who's prudent enough to pay for liability insurance. I'd rather have someone on the road that's that knows that, hey, look, you can make one mistake and your assets and you could have bankruptcy. You can go bankrupt just because I got a default judgment on you now, and you can't afford it. And now every time you try to get a job, it's going to be a problem. As opposed to, you know what, you probably should just pay for that liability insurance. Also, it also explains why you should have liability insurance. It also explains why it's probably to protect your own self against bad drivers, against people who don't have enough insurance policy. And if you're why victims should pay more. You don't need to just have a $25,000 policy. If you have kids in a family and people rely on you for their income, maybe you need a $100,000 policy, because if you get in one wreck, you can't go to work, and there's not enough policy. On the other hand, at least you have something that you're protecting yourself with. And that, to me, is not necessarily a moral decision. It seems like a prudent decision. Like, I'm weighing the costs and benefits, and I need to just and I need to do this in a more prudent way. And so I think many attorneys, when they hear the word moral, they think, is that really, the law is not really moral in many cases. Well, you know what? It definitely is prudent. We try to be at least better prudently than instead of just morally. And so again, this is a bit of I guess the end right here. This is the main problem of luck right here. And I guess I probably should talk a little bit more about luck. Like, the victim becoming a victim is being unlucky, right? Like, so you could sit at an intersection doing nothing, and someone just hits you, and it's just as a matter of luck, you're injured, you're a victim. That doesn't, just just more connect, I guess, to luckiness factor. Like, how much you're injured is also lucky. So how much money you're going to get is also lucky. So there's different aspects of this being lucky, in terms of the luck feature, sort of playing in here. But I'm going to hold for questions. I think there's some in the chat, but I think, but yeah, any questions, I guess? Thank you.
Thank you very much. Let's stop the share.
Okay, great.
Let me stop so we open for questions and answers. I was sending a message to Anna. Let me stop the recording now.